For Mr. Baptiste and Miss Woods, also for others who are present, just a little bit of information regarding what this preliminary hearing is. Our court has adopted this kind of information sharing at the beginning to make sure that this information is passed on. Because we don't get involved, you probably had heard all of this from your attorney, but I'm going to address it briefly here now today. In the interest of judicial economy, the preliminary hearing we're going to have today is going to be joined, but your cases have not yet been joined. I have not ruled on the motion for joinder at this time. This is not a judicial trial. This is a hearing, a preliminary hearing, meaning it comes at the beginning of the case to decide whether or not the case can go forward. The standard at this hearing is probable cause, and I will be determining after the evidence is produced whether or not probable cause is present, has been shown, has been proved by the state on each of the counts against you. I will make separate findings regarding each count and regarding each of you separately as defendants. If the court finds probable cause on any of the counts in the complaints, then I will be giving your attorneys an opportunity to state to make a statement of the possible evidence that they would like to present that they believe may overcome any finding of probable cause. Again, if I make a finding of probable cause at all, if I believe that that evidence would potentially affect my finding of probable cause, then I will allow your attorney to go forward and present that evidence. They have to provide the information to me of what that specifically, what that evidence is and who would provide it. At the close of that, if we go forward with any of that offer of proof by the defense in either of your cases, then I will find whether or not probable cause was overcome by anything that was presented there. I am a Superior Court judge here in Apache County, but right now I'm sitting as a magistrate for this preliminary hearing. That doesn't really change anything effectively, but affects legally what we're set here to do. There are still rules of evidence and procedure that do apply, but they are not the same as would apply at a trial. And so some things that would be allowed in this hearing would not be allowed, potentially would not be allowed at a trial. But there are some things like hearsay, for example, specifically provided in the rules that under certain circumstances, even though a statement is legally hearsay, it would come in during this preliminary hearing where it may not in the future. Ms. Collins, just to be sure, is there currently any offers by the state to the defendants in this matter, in these matters?
No.
All right. Because we do have limited time, also I'll mention for all of the parties that I will ask the attorneys to keep short on some things like training and experience or other qualifications of witnesses. That's not because it's not important, but because we want to focus on what we can and get through all of the evidence that we need to in order to accomplish what we need to today. Ms. Collins, I know you're aware we're a small county, so I'm aware of many, if not probably all of the law enforcement officers that you may be calling in the case. And so we don't need to spend extended time on training, experience, background, etc. Can just go forward to the facts related to the probable cause findings.
Yes, Your Honor.
Mr. Brewer, anything you need to address before we get started?
Judge, I think I'll let Mr. Lee lead. He filed a motion to continue today's hearing. I will be joining that, but I have additional bases to do that. I don't know if you want to hear from me. I can go ahead and no. So, Judge, as the court is aware, the state has filed an amended complaint alleging two fairly significant additions to the charges. two counts of molestation of a child regarding two separate children. And so that was done, I believe, late last night. At least that's when I got it, late last afternoon. And so there is a significant amount of material that's been provided to defense. And some of that pertains to these charges. However, prior to this, there was not a very extensive focus on that from my perspective, because those charges were not the ones that they weren't charged. And so I can't say I'm completely off guard, because there were previous complaints that alleged allegations of that nature, but they were then amended into having those removed, and now they're back. But I still think that to have a fair determination, there needs to be additional time given in order to prepare for those two additional charges. The other issue, Judge, is as the court can see, it appears that the state is planning on introducing approximately 95 exhibits in a preliminary hearing, and I can safely say that's the most I've ever seen in a preliminary hearing, probably a good chunk of trial hearings. But again, that is something that is, I assume we've been provided all these exhibits. I wouldn't think we have not been, but that was provided fairly recently, within the last couple of days, I believe. And to cross-check those exhibits with what we have is also fairly time-consuming and difficult. And so I would ask on those grounds too, that if the state, which I assume they're going to do, is try to introduce all of those for this hearing today, I would like a little more time to be able to assess any potential objections that would need to be made based on some of the rules, the Rule 5.4 specifically, the Arizona Rules of Criminal Procedure. Lastly, Judge, as the court's aware, at the first hearing we had in this case, Mr. Baptiste asked for his glasses to be returned. They were used for reading, and he has not had those returned. I found that out in a phone call yesterday. Otherwise, I would have made a greater stink about that, but he hasn't been advised that they are not giving him because of what the glasses are made of, or because of whatever. He has not been told anything. I believe the judge's order was to provide them to the jail. If the jail didn't believe they were appropriate, they needed to say something. Otherwise, the jail should provide him with ability to read. I mean, if he can't see what he is being charged with, how in the world can he assist his counsel in defending, in helping defend him in that? And so I think that's a basic. It's just like someone who can't read have to have someone go in there and read it to him. Otherwise, he can't assist. And that's basically where he is with his vision. And so I would ask, and it's not like we're dragging our feet. I mean, we asked for that at the initial hearing. The judge ordered it from my understanding, and it has not been complied with, or at least he has not got his glasses. And so for those reasons, we would ask for an extension of the preliminary hearing, because I think in order to have a fair hearing, we need to have that additional time. Thank you.
All right. Thank you, Mr. Brewer. I will turn to Mr. Lee next. Mr. Lee, I was made aware that there was something to be filed. I have not seen your motion.
And just basically, I cited Rule 5.1 C2 that allows the court to continue a preliminary hearing if extraordinary circumstances exist and it's indispensable to the means of justice to do so, to grant that motion. I suggest in my motion they're both present, that extraordinary circumstances. We got it online after hours, and didn't get it till this morning, the new charges. And there's at least 2 Class 2 felonies included that weren't there originally. I think that's a major change in the legal position of the state, and the defense needs time to prepare. I think it's a matter of fairness under the rule. Thank you.
Right. Thank you. Ms. Collins, would you like to address that motion?
Yes, Your Honor. And then I do believe actually Ms. Clace would like to speak on behalf of the victims. So I would object to the continuance request. Addressing the glasses, I don't think that's necessarily with the state. I think it sounds like the jail was sort of ordered to, but it also sounds like he didn't say anything until yesterday that he still hadn't gotten the glasses, and it's been a month. So in terms of that preparation, either he wasn't reading anything until yesterday or hadn't said anything, but I think that should be lower on the level of considering that for a continuance. In terms of introducing the exhibits, Judge, there is a list that is approximately 90 exhibits. The way we list that is to have the different supplements, because as this court and defense is aware, there's multiple agencies involved. And so with hearsay being allowed with the good basis, I have a deputy who has reviewed all of the disclosure, but if I need to show him a specific report, that is why they're labeled this way and split up separately so we can tell the difference between the different officers. In terms of what we would be admitting for the court to consider, there are medical records which all parties received. That was some of the first disclosure approximately a month ago, I believe August 7th. So the majority of the medical records from Little Colorado and from Phoenix Children, both defense counsel has had for a month, as is the pictures that came with it, the photographs of RB in both hospitals, of which we have pulled a couple for the court to consider for this hearing. Those are labeled as individual pictures. I don't think that would take an extensive amount of time, but they're labeled separately. And then in addition, there is a set of approximately 20 pictures of the outside of the residence and land and the inside of the yurt. So this court can understand the conditions that the children were living in. Again, that is probably almost 1/3 of what our exhibits are. So, and to answer the question that was sort of posed, they have, defense counsel has received all of this disclosure, and we made very clear, I would say, all of it, if but a few pieces, over a week ago, if not sooner. In regards to the argument of the 2 counts of molestation added, initially when this case was first charged, it was charged with sex assault. There are different elements that go to sex assault of a minor and molestation. The defense attorneys received the same exams of RB, KB1, and KB2 on August 25th. Each are 6 to 7 pages long. They're not extensive. They also received the pictures from RB's SANE exam. But you can tell from those reports where the state would have come up with the counts of molestation for RB and KB2 rather quickly. There is very vivid discussion about the bruising in the genital areas. And so based on that, Judge, there is no issue in terms of notice or preparation. And to be frank, I'm not entirely sure how they would have prepared differently, because they've had the evidence of the bruises and other injuries to KB this entire time from her pictures at the hospitals. And really the change would be the molestation charge with KB2. 7-page report. And it's very clear, Judge, from the statement from the doctor, as well as the diagram, why the state would have added those charges. We got those last week. We also were working with an expert doctor to try to kind of confer, because this is a unique circumstance. Adding them yesterday was where we felt best. But to go forward today is, I think, in the best interest of all parties, including the victims. Given that we've added those charges, they've had the evidence in front of them the entire time. And so based on that, Judge, I would object to a continuance and just allow Ms. Clace to speak a few.
One or two questions before I go to Ms. Clace. I believe I got it all, but the last date, I believe you mentioned, the most recent date that I heard you mention regarding disclosure, about August 25th. Is that correct based on your information?
SANE exams of all 3 children. And the photographs of RB from the SANE exam were disclosed on August 25th.
All right. Has there been any disclosure since that time that you're aware of?
We disclosed a few, so yesterday there was a disclosure of the DCS packet, but it's because I labeled it separately. There was approximately 49 pages. Those were included in the Phoenix Children's disclosure a month ago. We just separated them from the hearing. And then there was a supplement disclosed yesterday with Deputy Soto's information. Deputy Soto is the deputy on this 27th and 28th who went out to the different neighbors in the entire ranch. But they have had the body worn cameras of all of his interviews with them for approximately a month.
Right.
So we noted that we had all his body worns, but we realized yesterday we didn't have a supplement. That is my understanding. We did disclose the medical report from Dr. Woolridge this morning. I have no intention to including that in this hearing today. But that was a part of how the state determined we could go forward on the molestation charges.
All right. Thank you. Mr. Lee, I will come back to you. Ms. Clay, so I'll go to you first. Any position you'd like to address?
Yes. To the continue of today's hearing based on the victim's constitutional right to a speedy trial. Delays of pretrial proceedings will inevitably delay a trial date and a conclusion of the case. I am only the victim representative for the children. There are other next of kin. RB's KB1 and KB2's maternal grandfather is here. He is also a victim in the case, but it's my understanding that he drove up from the valley to be here today. So I'd ask the court to please move forward with with the preliminary hearing. Thank you.
Thank you, Ms. Clay.